Okay, I can see the numbers there. Thank you very much for joining us this morning. I hope everyone is well. This is our May webinar, and this is going to be where we have a look at some recent cases, but also a bit of a reminder of some of the cases that we've seen over recent months as well, just to give HR professionals a bit of an update as well as to what's been going on. We will be touching on some of the issues that came out of the Queen's speech. But for those who want to have more of an update in terms of legislation, but also immigration, then do check out our April webinar that I did with our Head of Immigration, Chris Harbour, and that can be found on our website or on our YouTube channel. So to today's webinar, really pleased to be joined by my colleague Katrina Flanagan. Brilliant to have you on board, Kat. And also Kat's been recently promoted as well to associate. So massive congratulations on that as well.
Thank you, Emma. Hi, everyone.
I thought it would be quite useful, Kat, just to sort of give people a bit of a flavour in terms of what is coming across your desk at the moment, maybe just to give a few of our listeners out there a bit of a sort of an update as well of maybe things that some other clients and employers are thinking about that might be something they want to think about as well.
Yeah, absolutely. So it's been really busy at the moment. I don't remember a time when actually it was quiet, but at the moment particularly busy, and we're still seeing a real varied mix of things that are coming in. So I work on a lot of litigation that takes up most of my day, but even within that, the kind of cases that are coming in are completely different. We've got lots of discrimination, we've got ordinary unfair dismissal, we've got TUPE, we've got equal pay. There's lots and lots of things going on at the moment. We're also seeing clients receive a lot more subject access requests. It's been a few years since the data protection legislation changed, and I think employees are becoming more and more aware of their right to request that and are certainly taking advantage of it. And then we're also looking at things like contract and handbook reviews, especially as things have changed over the last couple of years. People are looking at whether their contracts and policies are still up to date and reflect how they actually want to work. So a real mix of things going on at the moment.
I agree with you there, and I think as well with the litigation, you know, we sort of miss, don't we? And we sort of look back fondly on the days when we would get a simple, you know, one day unfair dismissal or a nice deduction from wages case. They tend to be much more complex and involve, you know, multi-claims. So, you know, it's unfair dismissal and discrimination and a bit of holiday pay thrown in for good measure. So it really is important to really focus on our processes and our procedures, and really, you know, kind of going back to basics on things. Just a bit of housekeeping. Kat and I are broadcasting to you live. You will be sent out the recording link and link to our YouTube channel. So again, please do share that with your colleagues as well. And again, for those of you who don't know me, I'm Emma O'Connor. I'm a director in the employment team and also head up our HR training academy. And for those that don't know Boyce Turner, we are a commercial law firm based in the Thames Valley that service clients across the UK and also Europe and globally, involved in a lot of processes now that involve clients who are multi-sited in, you know, various different jurisdictions. Our HR team not only does HR support, day-to-day HR support, but also, as Kat's mentioned, litigation as well, subject access requests. We also have a growing business immigration team as well, looking at sponsorship licenses and visa requests, as well as a busy training portfolio as well, not just for managers, but also boards and also wider HR teams and employee populations, looking at compliance issues, but also well-being and managing and leading teams as well. So a real mix of courses there. And before I started, I really wanted to sort of share with you a course that I've been running since 2017, bit of a hiatus, but we're back face-to-face for the HR Masterclass that I'm running over 2 days. On the 14th and 15th of June. I'm going to be running it from our Reading office. And it really is that chance for those of you who are listening, or perhaps you think about your own HR teams, or maybe you don't have an HR team, maybe you are HR. And really, you know, if there's anybody who is new to HR, perhaps they're returning from a career break, or they've moved into HR from a different part of the business, or simply you are just somebody who wants to have a refresher, meet other HR professionals, and really talk about the whole remit from, you know, start to finish. I've really designed this course with HR in mind. It focuses on the processes and procedures that HR will be involved in, from drafting contracts to managing performance issues. So it's run over 2 days, 9:30 till 2:30 both days, to give you the opportunity to, you know, put into practice what you've learned in the day. And I've just had my first international attendee booked. This is somebody who manages the HR function from the US head office, and they're combining the 2-day masterclass with a visit to the UK entity. So absolutely thrilled to bits about that, and looking forward to welcoming them. But again, that might be something that appeals as well if you've got HR support in a different location, whether you can combine that with the HR masterclass. I'll be sending out details, but again, it's really worth, I think, thinking about that when we go on to look at some of the cases, because a lot of them do reflect on processes and procedures where, you know, if things have been done differently, if managers knew what they needed to do, if HR were there to support and guide and lead, rather than making decisions for managers, some of the outcomes may have been different. Now, I do feel like it wouldn't be a webinar if I didn't refer to cases and issues that have been happening over the last 2 years. And the first batch of cases are cases that we have seen that have actually been brought sort of back in 2020, but have only just started to trickle through. And I think the fact that they've just started to trickle through really does highlight the backlog of cases that are within the employment tribunal system. And just to give you a bit of an indication, so you know, recently it was reported in Hansard that in respect of single claims, so whether the individual is just bringing a claim themselves, from the receipt of the ET1, so receipt of that claim form, to the first hearing, and bearing in mind the first hearing isn't the full hearing, it could be a, you know, preliminary hearing, that's taking, you know, 335 days on average to get to. And as I said, that might not be the full hearing, that can take place a lot longer. And where we have multi-claims, so where multiple claimants bringing claims against one employer, that's taking on average 388 days to get from the point of claim to the point of the first hearing. So, you know, that really does give some indication as to the length of time. And then on top of that, it's very interesting that, you know, a lot of the cases we're talking about are ones that may well be appealed. But again, you know, if it's taking almost a year to get from claim to first hearing, again, when you think about the time then it's taking to get to the appeal process, and anecdotally, you know, we've got an appeal running at the moment for a client where the appeal was lodged in August 2020 following the decision, and we've only just got a date in the diary at the Employment Appeal Tribunal for June 2022. So, you know, litigation is taking time, and it's something just to think about when you are, if you are involved in the litigation process, particularly where you've got witnesses and making sure that we keep, you know, memories afresh, etc. And the cases that we're going to talk about now, again, they came out of, you know, 2020, but the actual issues themselves are not new law. So the first two cases that we're going to have a look at focus on the issue of what is, or imminent danger in a health and safety case. So what do we mean by this? Well, under the Employment Rights Act, Section 44 and Section 100, an employee is entitled, where they fear that their health and safety is at serious and imminent danger, then they are able to reasonably leave the place of work, and any action that's taken in response to them leaving and because of the serious and imminent risk to their own health and safety. Again, that can be seen as a detriment, and any dismissal that may or may not follow from that would be automatically unfair. So the individual would not need the requisite 2 years service as they would do in other cases. But the question that was before the Employment Tribunal in the Gibson and the Fortuna Group case really focused on, what does this mean? What is a genuine belief that your health and safety is at serious and imminent risk? So, Kat, these are important cases. As we said, it's not new law, but I wonder if you could just sort of focus on that Gibson case for us and just give us an idea of what some of the facts were in that case and the decision.
Yeah, of course. So Mr. Gibson was a chef. He worked in a restaurant, and in 2020 all restaurants closed down, so he was placed on furlough. And then things started to improve a bit, and as we know, we started to come out of a lockdown. The restaurant asked Mr. Gibson to return to work, to start preparing the restaurant for reopening, doing all of that preparation that we know needs to happen. You don't just open the doors. Mr. Gibson had an elderly father who was shielding, so he was medically vulnerable. And he voiced his concerns about returning to work in light of his father, and said that actually there weren't safe working measures in place which would reasonably protect him from the risk of COVID. He was particularly concerned about the lack of PPE available at his workplace. And so he was concerned that he might catch COVID and that he might then pass it on to his vulnerable father. The restaurant didn't like this, though. So Mr. Gibson had said, "I'm not going to come back while you can't protect me." So the restaurant then sent him a text message and said, "If you're not coming back, you're dismissed with immediate effect." Understandably, Mr. Gibson decided he didn't like that very much. He was going to pursue an employment tribunal claim for unfair dismissal under Section 100 of the Employment Rights Act that Emma just mentioned. So in this case, the tribunal was satisfied that Mr. Gibson was unfairly dismissed. It was noted in the judgment that previously Mr. Gibson had been a successful and valued member of staff, so he wasn't a problem employee. He was valued. Therefore, it seemed unlikely that there was any other reason for the dismissal other than the fact that he raised these concerns and took steps to protect himself. And I think the context of his father in this case is important because it shows that there was this reasonable belief of danger. So he felt endangered himself from the lack of PPE, but with the added context of his father, that supported that. So this case was heard by the tribunal back in June last year. And as I said, the tribunal was satisfied that the dismissal was unfair, made a finding, and it cost the employer an award of £23,625. So that case is really showing that Section 100 was there and was very useful for employees who were dismissed during the pandemic where they were concerned about their health. But Emma, did you want to just talk about the next case, the Atticus case?
Yeah, and I think that's a really good point. And I think, you know, these cases were at their time. So what was reasonable at the time, not judging it by sort of what we knew in June 2021 or May 2022. It was what was what was known at that point where the employee felt, you know, my health and safety is at, you know, serious and imminent risk. And it does show, you know, that Section 100 does have teeth. And absolutely, Kat, you've got the Fortuna group case as well. Now, this was a case that wasn't necessarily about somebody feeling uneasy at work. Their argument was around they felt unhappy about commuting, and that was what they were unhappy about, and they actually asked to be furloughed. And perhaps ironically, this case, the employee worked for a company that sells and distributed PPE, and his job involved deliveries and sort of admin and things like that. And actually, the employer considered him to be a key worker, and therefore didn't accept that he should be furloughed. And it, again, very interesting. Mr. The claimant in this case again argued that he had been unfairly dismissed. He didn't have the requisite 2 years service, and so therefore the remedy open to him was to seek to argue automatic unfair dismissal under section 100. Now, what's interesting in this case is that actually the claimant was not successful in being able to show that it was reasonable for him to have that genuine belief. And I think that, again, what's sort of interesting, what's interesting sort of contrast with the Gibson case is that, again, it's very much looking at what the employer knew and what steps the employer could take at the time they made the decision, rather than sort of looking at it in, the benefit of the knowledge that you have in the future. So I think that's where, looking at what was reasonable at the time, and also looking at how reasonable was it for that employee to have felt the way they felt based on, sort of the wider context as well. So Kat, these cases, yes, we have seen more of them over the last 2 years, but again, it's not something that we would say would kind of be new law.
No, absolutely. It's nothing new, and these are first instance decisions, so these are just following the law that has already been in place for a long time. And as Emma said, they may still be appealed. We don't know. They're probably going to take a little while to get through the appeal system if they are being appealed. And I think what was interesting in the Fortuna case was that the claimant was quite vague as to what his concerns were. He didn't say, this is the specific risk that I'm fearful of, and this is why I'm taking these steps. And I think that was the case for a lot of employees at the time, is that there was this general fear, understandably so when you put it in the context of 2020. But just having that general fear, specifically as he was a key worker, wasn't enough to cross that threshold of showing that he reasonably thought that there was this serious and imminent risk.
And I think looking at the Kent Food case now, which we'll talk about now, this is another area that, again, isn't new law. It isn't a new concept. This is one where actually I would say we do get asked quite frequently, actually, by clients about this type of situation where it's not that the direct employer is asking for something to be done or putting in a requirement, but it's actually the employer's client. And what happens, often in situations is that the client has made a request, but your employee doesn't comply with that request. And so therefore what happens, because obviously that places the employer in a very difficult situation, because you obviously don't want to lose the client, but then you also have, direct obligations to your employee as well. And then so you end up in this sort of, very tricky balancing situation. And in the Kent Foods case, Kat, this is one where, the claimant here was a delivery driver, wasn't he? And one of the Kent Foods' clients put in a request there to wear a mask, and he refused. So, pick up what happened after that.
Yeah, so the requirement from the client was to wear a mask at all times while on their site. And the claimant here said, well, I will wear a mask sometimes, but not all of the time. That didn't comply with the client's policy. And the client's policy was very clear: if you're on site, you're wearing a mask.
Now, he's a delivery driver, so he's going to be in his
Absolutely.
cab, isn't he? He's in his cab
Yeah.
by himself. Yeah.
And it was that period that he was in his cab that he didn't want to be wearing a mask. As Emma said, he'll be in there on his own. But the policy was still very clear that the vehicle is on site, he is on site, therefore he should be wearing a mask. So the client went to Kent Foods and said, this is unacceptable, we won't have this driver here if he's not going to comply with our policies. And they put it that simply: we're not having this driver back. And so Kent Foods carried out an investigation. They looked into it. They followed their internal disciplinary process for failing to follow the client's policies. And he was ultimately dismissed for gross misconduct. He didn't like this, again, said his dismissal was unfair, brought a claim to the Employment Tribunal on that basis. This is just ordinary unfair dismissal now, so moving away from the Section 100 claims that we were talking about before. Interestingly, the tribunal said that while they may have issued a warning, the employer's decision fell within the range of reasonable responses. And this is something that applies more widely, because the tribunal's duty isn't to tell employers what they would have done in the situation, because we all think slightly differently. There is a range of things that a reasonable person might have done. So the tribunal accepted that actually in this case, one of those reasonable responses was dismissal on grounds of gross misconduct. Therefore, the dismissal was fair. And a few things that the tribunal really kind of pinned importance on in this were looking at the importance of maintaining that good client relationship. And so this is where it applies more widely than just in relation to COVID specific policies, but there is commercial requirements to maintain good relationships with suppliers and customers. So the tribunal does recognise that and referred to that specifically in this case. The claimant also interestingly said that he didn't accept that he'd done anything wrong. And so that then put a concern in the employer's mind that he would continue to carry out this course of action, and that he may behave the same way again, and it may cause further issues for them going forward. And the tribunal also recognised the practical difficulty of having a driver that was banned from a client site. A delivery driver needs to go where the deliveries need delivering. So the tribunal does recognise these practicalities. While they may not necessarily agree that they would have carried out the same course of action, they appreciate the reasonableness of the employer in this situation who'd followed a fair process to get to this point. And I think the process here is very important.
Oh, totally. And I think his lack of remorse as well probably, contributed a lot to that decision. And as I mentioned, we do get, I would say, a fair few of these queries. And I think that, what employers, the sort of direct employer has to remember is that, you do owe that duty to your employee. And really, dismissal should always be, the last resort. So do look at those alternative options. Can you redeploy? Is there anything else you can do? Can you change what the individual's doing and who they're delivering or providing the service to? So I think always focus on that process, always focus on getting trying to get it right, maybe not perfect, but trying to get it right in those situations. But yeah, as Kat said, it is a balance, the competing rights there in terms of commerciality as well. A couple more cases, and this one's quite an interesting one again. Raises that issue of, you know, social media misuse. So all was fine with Mr. Lynch. You know, again, this is a 2020 case. So all was fine with Mr. Lynch. He was a delivery driver for Domino's, and Domino's basically said to individuals, you know, if you want to, you can take the option of isolation, being in isolation, but you will be unpaid. Mr. Lynch accepted that, and, you know, all was well until he took to social media, and Facebook in particular, to make a comment about Domino's, and as he thought it was a disgrace that Domino's was still delivering pizza during a national lockdown. And again, he didn't leave it there, but continued then to have an online spat, which was always polite terminology, isn't it, for a bit of fruity language, with a fellow employee, where basically Mr. Lynch ended up threatening the employee with violence. So again, we have our sort of, you know, scenario that we've seen before, of where you've got an employee misusing social media and threatening an employee. He was dismissed for making these threats. And again, he argued that his dismissal was unfair because he had made what he said to be health and safety disclosures, which, as we know, fall within the whistleblowing protection, where again, employees don't need that magic 2 years service. So what happened with Mr. Lynch, and what happened at again, this is a tribunal case, Kat?
So the tribunal agreed with Domino's. This was a fair dismissal, and it was fair to dismiss him on grounds of gross misconduct. In coming to that decision, they did refer to these comments about health and safety, but said that even if they amounted to protected disclosures, even if he had blown the whistle, that was not the reason for his dismissal. So for a dismissal to be automatically unfair because of a whistleblow, the whistleblow itself has to be the reason for the dismissal. And here it was clear that actually the reason he was dismissed was this spat with his colleague. Now, we don't know exactly what was said, but it was clearly bad enough that he could be dismissed for gross misconduct. And that's completely separate to any issues he might have had in relation to the health and safety of Domino's operation during a lockdown. So it doesn't mean that just because someone has whistleblown that they can't still be managed or can get away with unacceptable behaviour, as Mr. Lynch exhibited.
No, absolutely. And again, we've got a case involving solicitors, which is always sort of an interesting one when you see your fellow professionals in the tribunal. And this was one where again, it does derive from, you know, a 2020 situation where the legal firm gave employees the choice of whether to accept a 20% pay decrease, or cut in their hours, or go on furlough. So what they were proposing was a contractual variation, as many employers did during that time. And in this situation, the solicitor actually refused to sign a variation to her contract. And basically what the employer were trying to say is, look, we basically want the right that within 5 days, so we can basically give you just 5 days notice to implement one of these 3 options. And employees, we want you to sign and agree that we will have, you know, basically the ability to give you, you know, 5 days notice in which to make these changes. And the employee here refused to sign that. And as a result, she felt that, you know, she had no option, and she was effectively dismissed for failure to sign her contract, and she did bring a claim against the employer in the employment tribunal. And again, Kat, what was the outcome in this case?
So this one, the tribunal found that the employer, so the solicitor firm, did have a fair reason for the dismissal. So they could have dismissed her fairly on the basis of some other substantial reason. So that catch-all that says it doesn't fit into one of the other categories, but there is a valid and fair reason for dismissal. However, the way the firm went about this meant that actually the dismissal was unfair. So while they had sound, good business reasons for it, the decision was unfair on the basis that they had almost no meaningful consultation at all in relation to this proposed change of contract. And it was almost decided from the start of their process that any employee that didn't sign this variation would be dismissed. They didn't look at any other alternatives. So at the time the furlough scheme was in effect, they could have considered whether they furlough employees, whether they moved to part-time working. There are lots of things they should have considered and didn't. And they just completely disregarded the existing terms that were in place and said, we need you to sign this or else, effectively. So because of those failures, it made the decision unfair, and it made the dismissal itself unfair, even with these good business reasons for needing to make that change, which again, I said it in relation to one of the other cases, but process is so important. Because it can take a fair dismissal into an unfair dismissal.
Absolutely. You know, you need both, don't you? You need that fair reason justifying the dismissal. But that isn't enough. You need the process as well. And, you know, as you've said, Kat, you can have the fairest of reasons, but the most awful of processes, and the dismissal overall will be unfair, which is why it's really important to, you know, go back to basics and make sure that you're getting the process right in all these cases. And I think that's been a useful reminder of, you know, the fact that we do have this sort of, you know, trickle of cases that are coming out from sort of, you know, 2020 and lockdown and COVID, and what employers knew and what employees knew. But again, these are sort of legal processes and legal principles that we've been grappling with, you know, for a long time. And it's just a useful reminder, I think, just to sort of, you know, that these cases are coming on board. And we will see more likely to see more of them as well. Another set of cases that I want to sort of just come on to have a look at involves equality and diversity. And the first case involving Miss Mackin is interesting actually for a number of reasons. It's interesting because of the compensation award that Miss Mackin was given of over £2 million. And often when we are advising clients of cases, you know, we'll do that risk assessment and we'll often say, okay, well, what's the potential compensation? And, you know, where you've got an individual who is a high earner, as we know, compensation for discrimination is looking at that loss of earnings. So if you've got that individual who is a high earner, then their losses will be greater. We don't have any kind of cap in discrimination cases. Yes, we do have what we call the vento bans when we think about that injury to feelings that is also an element of compensation for discrimination. But in discrimination cases where you've got that long period of less favourable treatment, where you've got that campaign against an individual, you know, a campaign of bullying or harassment, and also where you've got an employer who is, you know, advised that there's something not right, but then fails to act. You know, all of those issues get sort of thrown into the compensation mix. And it's really important that, you know, to note, yes, this is a high award, and it's high for lots of different reasons, but also to remember that discrimination cases are different. We don't have that cap. And it is very important, you know, we'll come on to talk about the facts now of this case. Another reason why this case is important is because it shows the power of the employment tribunal in discrimination cases, not just to award compensation against the employer, but the other options that it has at its disposal as well. So, Kat, I know the facts of this are quite sort of long, but I just wonder if you could sort of really sort of focus on those issues that came up in the case, and why it was such a long time. The facts were over such a long time.
Absolutely. So this lady, Miss Megan, was employed in 2013, and really her claims date all the way back to 2013, which is why this award is so high. Because as well as a discrimination claim as we ordinarily think of them, she also brought an equal pay claim. So she had a starting salary of 120,000 a year, but her peers, her male peers, had a salary of around 160,000 at the same time. So already £40,000 a year difference in salary, plus they had substantially higher bonuses. So over a period of 4 years, her male counterparts received bonuses of over £167,000, while she received only 33,000. So we're already starting to see how the value of this claim can really add up quite quickly. So in addition to being paid much less than her colleagues, she was also subjected to a campaign, as Emma referred to it, a campaign of sexist behaviour. So people would get drunk and leave a witch's hat on her desk, for example. They would brush her off and say, "Not now, Stacey," and really just discussed some very inappropriate workplace things in front of her that constituted sexual harassment. So this claim is quite an old one now, and it's quite a good example of how litigation can take a very, very long time, because this judgment was originally handed down in 2019. So the judgment to say that actually she was doing work equal to her male colleagues, and so should have been paid equally, and that she had been subjected to sex discrimination. So she's known for 3 years already that she has been successful in her claim. But it's taken until very recently, I think it was last month or maybe March, that she had her remedy hearing. So after being successful, she's had this wait, and they've now had the hearing to decide how much she was owed. And as Emma said, it was over £2 million in total. So 400,000 of that was back pay, so pay that she should have been entitled to while she was employed. Because of the serious campaign of sexist behaviour that she'd been subjected to, she received a really high award for loss of earnings for future earnings, £860,000. So as we said, she is a high earner, but that is still years and years worth of salary. And because of the
personal
impact.
Injury as well, wasn't it? Personal injury as well is another area of compensation. That,
absolutely. So more than 200,000 in injury to feelings. So all of these are huge numbers, but when you add them all together, you get to that £2 million mark. And that's why it was reported in the press, is that actually that's a huge number, and is newsworthy that someone's received this £2 million for this treatment by a very well-known bank. Interestingly, the tribunal also has ordered an equal pay audit, and the bank have said actually we've voluntarily been doing those now anyway. So it didn't help them to say, well, we've started doing them, because the tribunal acknowledged that kind of ingrained and systematic sexism is not going to have changed that quickly. So there is a requirement now for them to keep looking at that, to make sure that these things don't happen again.
And, you know, with my process and my procedure hat on, it would be remiss of me to add to that list of compensation for personal injury, injury to feelings and income, that actually the bank failed to follow the ACAS code of conduct in relation to disciplinary and grievance. And as we know, employers who fail, and also, you know, employees as well, employers who fail to follow that code, compensation can be uplifted. And in this situation, over £300,000 was added to the claimant's award because the bank had failed to follow the ACAS code. So again, processes are important. Processes can increase compensation. And, you know, when you've got numbers that big, you know, it's only going to make them bigger. And I do want to touch on a case that I'm sure many of you saw in the press. I posted it on my LinkedIn account, and I've had, you know, about 1,500 views of my post. So it is something I think that people are, you know, are interested about, because it was perhaps something we're not used to seeing. And this was a male employee, bringing a claim of sexual harassment, of, you know, harassment based on sex, a protected characteristic, as we know, under the under the Equality Act. And he brought that against his employer on the basis that his manager said on 2 occasions, some years apart, I would add, but there were 2 altercations with a manager over health and safety issues. So not just, it was, you know, related to incidents at work. And the manager called this chap on 2 occasions, referred to his baldness and also an unmentionable word. This is a family broadcast, so I won't be saying what it was, but you can read it in my post or online. And actually, you know, this was a really interesting case because it involved a man. And also the point, Kat, that because obviously under the Equality Act, an act of harassment has to be based on or linked to or associated with a protected characteristic or a perceived protected characteristic. There was a big discussion about whether being bald is a male trait, which I thought was quite interesting, particularly in light of obviously what we've seen with what happened at the Oscars. And so it's quite interesting that this was something that was discussed in great detail. Was baldness related to sex, and you know, being something that men are inflicted with more than women. But I thought it was very interesting that was something that was raised during the hearing.
Absolutely, and it was. I don't think any of us previous to this case would have thought referring to someone as bald can amount to sex harassment on grounds of sex. He did also try to bring this claim on the basis of age. So the real focus of it is his sex, because that's what he won on. He also tried to say older people are more likely to be bald, therefore it's also age discrimination, harassment on grounds of age. He didn't get very far with that. That claim was not well founded. And the tribunal held that effectively you can be bald at any age. But they did find that baldness is an issue which predominantly affects men. There are, of course, as Emma said, women who have issues with baldness, with hair loss, all of those sorts of things. But because it's generally considered a male issue, that was enough for it to amount to harassment related to his sex. And so I think it's important that we put the comment into context, but it makes you think about that office banter of people saying things that they mean as a joke, but now that we've heard this case, puts those sorts of things into a new light, and you really need to be considering how it could be viewed and received. As Emma said, this was part of an altercation, so it wasn't all the lads sat around having a jolly. And I think that's important, because for harassment, you can have it where it's the purpose is to harass someone. And it seems that that was more the case here, because the manager, there was an altercation, they were not being nice to each other generally. Whereas harassment can also be because a comment has that effect, regardless of whether there was the intent. And I think that's why this needs to be considered more widely, because if you're having a laugh and a joke with someone, but they reasonably consider that actually that oversteps the mark, they may still then bring a claim for harassment on this basis.
Absolutely. And I think, whilst we're looking at the cases, it's worth just to remind ourselves of a case that, it isn't new, but it is very recent. And it does talk about really those steps that employers can take. And it's a useful reminder about what steps employers can take. Not just because under discrimination and harassment laws, there is a statutory defence which employers can use that says, we have taken all reasonable steps to ensure that this type of behaviour does not go on within our workplaces, but also because it's the right thing to do these things, and to make sure that your workplaces are inclusive and they are safe spaces, and you have that culture where people can speak up, that it's not okay to say these things. And I think what this case really does demonstrate is that it's not enough just to have a policy. It's not enough just to do a bit of ad hoc training every now and again. If you are going to run manager training, it's got to be not just the awareness piece, but also the legal piece as well. What are the legal risks, not just to the employer, but also to you individually as a manager? And then ensure that that message is disseminated down to the wider workforce to demonstrate that this, we don't have a culture where this type of behaviour, these types of comments are tolerated. And again, that training needs to be refreshed. It needs to be refreshed 18 months, 12, 2 years at an absolute minimum, because again, the information can become stale. Another point that the employer in this case was criticised for is that, yes, we talked about direct discrimination and indirect discrimination, but what we didn't do was focus on sort of really drill down into what the examples are. And in this case, it was a manager making stereotypical comments to an employee. And again, it's about, reading the case, it's sort of almost, sort of common sense. We just don't say these things in the workplace. But again, reinforcing the messaging that, yes, it's about direct, yes, it's about indirect, yes, it's about harassment, but it's also about those stereotypes, those stereotypical jokes, comments, whether it's on social media or face-to-face or on, WhatsApp groups, that behaviour is not tolerated. And again, it's about then having that paper trail, isn't it? That, we're reviewing what we're doing, we're monitoring what we're doing, we're seeing how effective that is. And if things aren't working, what are we doing to change what we're doing around the messaging? And again, having that mechanism and that ability where people feel they can speak up when things are not quite right. And when they do that they're taken seriously. So again, let's go back to this case. There are some really good takeaways there for employers about adopting that approach, adopting that open culture approach, that this kind of behaviour is simply not okay and won't be tolerated. And these are the consequences if we find that somebody has engaged in conduct which we consider to be inappropriate and is not the good management behaviours that we want to instill. So it's been a busy caseload, but it also, I just want to sort of touch on the Queen's speech that obviously happened this month, and whatever happened to the employment bill, because I've been talking about the employment bill, writing about the employment bill since it sort of popped its head up in the Queen's speech in 2019, and we were all very excited about, would flexible working become a day one right? What would that look like? Would we see some changes to the 8 statutory grounds when an employer can refuse a request? we've got excited about carers leave and neonatal leave, and also rights for employees returning after maternity leave, that they would be protected against redundancy. But absolute radio silence in the Queen's speech. It's going to be very interesting to see if these initiatives do again come back. We simply don't know. Parliament has obviously got not enough time to consider these issues, but you know, let's think about where we are in terms of recruitment, in terms of engagement, in terms of, you know, being that destination employer that we all want to be. You know, these are perhaps some you know, policies there that we may be able to implement to make us stand out from that crowded employment market. And again, you know, although we were radio silent on the employment bill, there are some points that we do think, you know, are ones to watch. And I just want to mention there about the extension of the gender pay gap reporting. We've talked a lot, haven't we, about ethnicity pay gap reporting, disability pay gap reporting, and some of the issues there. Again, check out our recent article on that. But really, it does go down to, yes, some employers are caught by the legislation, some employers are not now, but they may be. So really think about the benefits of reporting on your gender pay gap. You know, even if you're not caught by the legislation currently, what does that say about you? Does it mean that you can kind of start your journey now in terms of how you're looking at your pay gap between men and women, or perhaps with different ethnic minorities within your business? So again, you know, we are helping a lot of employers with their gender pay gaps who aren't caught, and it's really interesting to see them sort of start the process now, because, you know, they hope to be, you know, sort of grow, and then they will be called. So almost like they're getting on the front foot of being able to show that they are taking these issues seriously and what they're doing about it. And, you know, we saw that there has been talk about the reintroduction of harassment laws, and particularly around that third party harassment, and also some other changes as well. Kat, what might we see in terms of sort of sexual harassment laws changing?
So it's really the focus on third-party sexual harassment that's being talked about the most. So ensuring that people aren't subjected to sexual harassment in the workplace, regardless of who that sexual harassment, who the harasser is. So making that a specific piece of legislation, and to make workplaces safer for employees. It's a real focus on employers taking that step to protect employees. And as Emma said, the training and the policies and things are important, but it's putting that specific duty, a positive obligation on employers to make sure that they are creating a safe and fair workplace for everyone. And they're also looking at a potential extension to the time limit for bringing claims. So in the event that something does happen, there's currently a 3-month time limit for bringing a tribunal claim, subject to the ACAS extension. That's a really short period of time, especially if this has been really serious discrimination. You can imagine the effects this might have on someone. So for that added pressure to get your claim in within 3 months puts claimants to a real difficulty. So Parliament are looking at extending that from 3 months to 6 months. Now, this is all when parliamentary time allows. So we've got no specific time frame for this at the moment, but those are the sorts of things that that they are looking at, and that we expect to come in at some point.
Yeah, that great phrase, isn't it? When parliamentary time allows. Yeah, that's become a bit of a kind of a stock phrase, isn't it? With sort of changes at the moment. And again, this might sort of raise an eyebrow with some of you. The retained EU law bill did get a mention in the Queen's speech. This is one where, you know, again, when parliamentary time allows. It will be one where there will be a look at those laws that have come specifically from Europe, so holiday pay rules, agency worker rules, TUPE, where we may see a bit of tinkering around the edges of some of those. So again, you know, watch this space. If there's an ability for people to put their views forward during consultation, then do, because, you know, this is one where there may be some ability to sort of change some of the aspects. I don't think we'll have a wholesale, you know, repeal of anything, but there might be some sort of tinkering around the edges there to support businesses. So do look out for consultation. So thank you very much for joining us today. Here's our contact details if you have any questions or if we can help further. Book up for the HR Masterclass. Really excited to be running it. Great to see people face to face, run an in-person training event. So really looking forward to that. And hopefully the cases that we've shown you really do focus on how important it is for HR to be able to support, to know the processes, and also to be able to understand what the risks are. So again, do book up for the masterclass, and I'll be sending out details of that. Our next webinar is on the 23rd of June, where we're going to be looking at community and communication, the essential workplace ingredients. So if you are intrigued to know what community and communication webinar will be all about, then book up, please, and look out for invites coming out on that next week. So that brings us to an end. We have managed to fill the whole hour, Kat. So thank you very much for joining me.
Oh, thank you very much. It was great to speak to you all today.
Brilliant. And again, looking forward to seeing you all, hopefully in person at the masterclass or on our webinar next month. Thank you very much.
Duh.